had one of our worst, coldest, wettest winters ever. So
I've heard.
anyway, thank you so much, Marius, for doing these sessions for
Oh,
us.
thank
Without
you.
any further ado, I'm going to hand over to you.
Thank you. Right, morning everyone. Guys, hope you well. So today, guys, if last month, and I agree with Michelle, it seems like last week we discussed this, but last month we spoke about the contractual capacity of individuals, and what we're going to discuss today is the contractual capacity of incorporated entities. So we're going to talk about companies, closed corporations, and trusts. Guys, part of my, in fact, the next three slides, or three or four slides I'm going to show you are probably the most important. So what I'm going to do is I'm going to start with a kind of a high level discussion of contracting with companies, closed corporations, and trusts. This is the stuff you absolutely need to know. And then I'm going to drill down into some of the detail around it, which is for your information. You don't need to study it to like know it, but I'm just going to give it to you so you've got a broad understanding, right? So let's start with companies. So when we deal with a company, and of course, guys, the first thing we're going to do when dealing with a company or a closed corporation, you must do a CIPC search, because our CIPC search is going to tell you, in the case of a company, who are the directors. In the case of a closed corporation, who are the members of the closed corporation. Okay, and in the case of a company, it needs to be understood that it's different from a closed corporation. A closed corporation is managed and owned by the members of the closed corporation. So when I do a CIPC search, the members are the people who own and manage that closed corporation. With a company, it's slightly different. When I do a CIPC search, it's going to tell me who the directors are. So the CIPC search to tell me who the directors are only. But the directors are the people who direct the company. And then we have shareholders, and shareholders are the people who own the company, right? Right now, as we stand, you can't do a search on the shareholders. You can only do a search on the directors of the company. Okay, and this is of course important for various reasons to understand, because the management of the company is vested in the directors of the company, and the shareholders own the company. Now, in the vast majority of the transactions you guys are going to be involved in, the directors and the shareholders will be the same people. I mean, not always. I mean, we're not dealing with Anglo-American where there's directors and very distinct shareholders. Normally, we'll have a case of it'll be Marius van Rensburg the director, and Marius van Rensburg is the shareholder. Or we might find a case of Marius van Rensburg is the director, and Marius van Rensburg's trust is the shareholder of the company. All right. So what we need to understand about companies is that there's two kinds of resolutions that we can pass. Okay. The first kind of resolution is a director's resolution. So when a company sells an asset, and that asset is not the majority asset, so the asset in terms of value doesn't comprise more than 51% of the company, then the directors can sell it. All right. But if the asset, which is going to be the most of the times when you guys are involved in these sales, when the asset is the company's majority asset, all right. So in other words, the company owns an asset, the only asset, or that asset comprises more than 51% of the value of that company. All right. Then what we need a shareholders resolution. Okay. And that shareholder resolution in terms of section 112 of the Companies Act, which was previously section 228 of the Companies Act, for those of you familiar with the terminology of a section 228 resolution. So what we're saying here is this: when a company sells an asset and it's the majority asset, the decision is so important to the company because it's the company's only or majority asset that our legislature says to us, hold on, guys, the directors alone can't make this decision. We must now go to the people who own the company, and they must authorize the sale of this property. And why is this important? Because the Companies Act makes it obligatory to have this section 112 resolution. And there's been a bit of case law coming out recently that really what it speaks to is telling us that in the case of a company, we have to have the 112 resolution before we enter into the transaction. Okay. So the agreement must either be subject to a 112 resolution, or you must have it at the time where we do it. So it's not commonly known or understood, but that is kind of how it works. But let's move on. We'll come back to this in a second. The next thing I want to tell you about companies is that you can register a company. You can register for in the name of a company to be formed. So you can have a company that's so my example is Joe Black for on behalf of a company to be formed. Now the company doesn't exist, so Joe Black is the representative of the company still to be formed, and that's what you say, Joe Black for a company to be formed. And then of course you need to have the clauses in your agreement, which I know that you do. The clause in your agreement that says, okay, Joe Black as the signatory, you must now form the company within 6 weeks. Now, you can form a company, guys, within 4 or 5 days. It's really actually quite simple. It's very quick. But what Joe Black's obligation is, and there'll be clauses in your agreement that say Joe Black must form the company within 30 days. And once Joe Black forms the company, Joe Black must now pass a resolution to adopt and ratify the pre-incorporation contract. So just for you guys to understand, you can contract for and on behalf of a company to be formed. Guys, please don't do Joe Black for a company to be formed or nominee or something. Don't use the word nominee. Nominee has a totally different meaning, has a totally different legal and transitory consequences, and we need to just try and avoid it insofar as we can. When dealing with a closed corporation, and by the way, guys, I've got examples of the resolutions at the end of this of the slide, so we'll go through what those resolutions look like. So when dealing with closed corporations, as I've said, you've got the members of the closed corporation are also the owners of the closed corporation. So you do a CIPC search. Of course, you must determine if the company closed corporation is still in business, and then we'll know who the members are. Now, when it comes to closed corporations, we need to have 75% of the members of the closed corporation all willing to dispose of the assets of the company. So, if we're going to drill down into this, if there's an association agreement, we'll look at the association agreement. Otherwise, what we're going to do is we're going to look at the actual Companies Act. Guys, when it comes to companies and closed corporations, all right, we can't, and I'm going to deal with this in one of the further slides. We need all the directors and all the shareholders to sign our resolution. In the case of a closed corporation, I need all the members of a closed corporation to sign, because whilst the legal limit for a closed corporation to sell its majority assets, we need 75% of the members of that closed corporation to sign the resolution. It's a bit more technical than that, and I'm going to explain that in the next slide. For our purposes, if there's 4 members and only 3 guys want to sell, then you need to reconsider whether this property is saleable, because in our case, we can't drill down into that detailed process of calling a meeting and having the resolution passed. We for our purposes, we need all of the members to agree. If they don't agree, you're welcome to call me, and then we can discuss it. Guys, please note, if you look at the last paragraph on the slide here, right, you can't you can't contract for and on behalf of a closed corporation to be formed. And the reason why you can't contract for a closed corporation to be formed was because the Companies Act of 2008, and that also seems a very long time ago. But that legislation, what it effectively did was it removed the sections that enable the registration of new closed corporations. So what I'm saying is, in terms of our law, it's currently not possible to register a new closed corporation. And that's why you can't say Marius van Rensburg for on behalf of a closed corporation to be formed. What you can do is have Marius van Rensburg for a company to be formed, but not a closed corporation. All right, guys, when it comes to trusts, guys, you must understand that the structure of a trust. A trust has trust assets, it has trustees, and it has beneficiaries. The trustees are the people appointed in terms of legislation to look after and manage the trust. So when we're dealing with a trust, what we need to do is we need to ask the people we're dealing with for copies of the letters of authority. So the letters of authority are issued in terms of Section 6 of the Trust Property Control Act. And only once the letters of authority are issued by the trust, are those trustees authorized now to deal with the business of the trust? So you have to get copies of the letters of authority, and once you have the letters of authority, you can see who the trustees are. Okay, and those are the only people who can actually act on behalf of this trust. So, guys, the way the law works, and I'm going to demonstrate this in terms of a case which I've got, which I'll show you now. The way this works is that when it comes to a trust, first of all, you can't contract for and on behalf of a trust to be formed, right? It's simply not possible in terms of our law, in terms of the Trust Property Control Act and our case law, okay? When you're dealing with trusts, it's absolutely essential that either the trustees must all act jointly, i.e. they all sign your offer to purchase, or you must have a resolution of the trustees where the trustees authorize one of their number to sign the sale agreement. And that resolution must predate the sale agreement. It absolutely needs to predate the sale agreement. It can't post date the sale agreement, because if it post date the sale agreement, your agreement is null and void. And we know this because there's a Supreme Court of Appeals case, which is Thorpe versus Tritton Ryan and another. All right. So essentially, what happened in this case was that there was a purchaser, and the purchaser was a trust. Okay, the sale agreement was entered into, and there was 3 trustees of the purchaser trust. Okay, now what happened was the 3 trustees sat together, had a cup of coffee, and decided that one of their number was going to sign the offer to purchase. But there was no resolution entered into. So in other words, this one trustee wasn't authorized in writing. Okay. And then there was a dispute around whether this agreement was valid or not. And what happened was the purchaser trust brought an application to court. Okay. And the purchaser trust brought the application for a court to confirm and declare that the agreement was valid and binding. And what the seller did was the seller said, no, the agreement is not valid and binding because the trustee, the trust who signed the agreement on behalf of the buyer trust didn't have authority in terms of Section 2.1 of the Alienation of Land Act. Okay. So the issue to be decided was the agreement of sale valid and enforceable under circumstances where there was only one trustee who signed the OTP, and that trustee was not authorized to sign the agreement in writing. So that's what the court had to decide, right? So the court looked at Section 2.1 of the Alienation of Land Act, and 2.1 says, no alienation of land after commencement of this section shall be of any force and effect, unless it's contained a deed of alienation signed by the parties or by their agents acting upon their written authority. So, or by their agents acting upon their written authority. This is of course the crux of the matter. So what this tells us is that the legislation not only requires the agreement to be in writing, but it must be signed by the parties. And if the parties aren't personally represented, they must be, the people who sign on behalf of those parties must be acting upon written authority. And in this case, that simply was not the case. So what did the court held? The court said the agreement was null and void. Okay, that's what the court held. The agreement was null and void. It couldn't be ratified after the fact. It was simply dead. The court said, listen, the trustees who must either act jointly, i.e. they must all sign the agreement of sale together, all right, or they must enter into a resolution that predates the sale agreement, because then we can authorize one of the trustees in writing prior to the signature of the agreement. And guys, this is the reason why when you're dealing with a trust, it's so important for us to get the resolution signed by the trustee that predates the sale agreement. And guys, don't skip over this. Don't skip over this, because remember that when the agreement comes to us as conveyancers, our job, we can't let it go through unless we've complied with the Alienation of Land Act. Because when we sign our prep clauses, and I'm giving a talk to the Joburg Leapfrog Northeast agents next week Friday on the conveyancing process, and I'm going to talk about the preparation clause and Regulation 44 and conveyancers' responsibilities. We certify at the deeds office that the people who signed this agreement and signed our documents are properly and duly authorized. So remember, guys, that people buy and sell property all the time, and they regret their decision for 100 different reasons. Now they want out. And I can tell you, our litigation guys, every single time this comes up, our litigation guys go, was there a resolution for the trust? No. Okay, the deal's dead, and then we move on. So that's why it's important for us to make sure that we cross the T's and dot the I's, because you go to all this effort to do the sale, and that people change their mind, and then you're in a situation where the deal dies. Okay, guys. So the next couple of slides, I don't want you to turn off or go away, but I just want you to understand that this is some slightly more detailed explanations, right? So I've got two scenarios that I want to cover. One is I want to give you more detail about Section 112 of the Companies Act, and two, I want to talk more about closed corporations, and then I'm going to finish by we're going to be looking at some examples of some resolutions. Okay, so as I've said before, the Section 112 is a successor of Section 228, okay, where a company sells the greater part of the undertaking of the company or a greater whole part of the assets, then we need a Section 112 resolution. So in other words, where the company sells the immovable property, which comprises more than 51% of the value of the property, okay? So then what needs to happen really is the directors can't enter into resolution on their own. What they need to do is they need to call a general meeting of the company, an AGM, or they need to call a special general meeting which is an SGM. Okay, so in other words, what we do is we circumvent this whole process by having one resolution and everyone signs it. We all agree. We waive the time periods. The directors sign, the shareholders sign, and Bob's your uncle. We have a good resolution. This is a procedure. This is the formal procedure that a company is supposed to follow in the background to pass this resolution. Okay. So what is a special resolution? Special resolution is a resolution passed by 75% of the shareholders of the company at a general meeting or a special general meeting, right? Why is it required? Well, it's required in terms of Section 112, as I've said before, that we're disposing of the majority of the assets. So what we would do is we would decide, great, as directors, we want to sell the property. We need the permission of our shareholders. So we would send a notice out to all our shareholders, call a general meeting or a special general meeting, and we would propose the special resolution. When we get there, we need what's called a quorum. So we need to have a certain amount of people, of shareholders at the meeting to have a quorum. And in this case, what the Companies Act says is we must have shareholders at least comprising 1/4 of the total votes of all the shareholders. If we've got 1/4, we can have our meeting. We call out a resolution. We call for a show of hands, and we must pass that resolution by 75%. Can we relax the time period to attend these meetings? Yes, we can. So what we can do is we can sign a document that says we're going to waive we're going to waive this requirement. And then the last issue is, well, must a special resolution be registered in the Companies Office? No, it doesn't. And the reason why I raise this is because the old Section 228 resolution, in terms of the old Companies Act, the special resolution it was so important, it had to be registered at the Companies Office, but that's no longer the case. Okay, but guys, this is for your background information. What I'm suggesting you do is I'm suggesting you get the resolution. If they can't get the resolution, they will follow this process on their own. Okay. Again, when it comes to closed corporations, what we're going to do is do a CIPC search, see who the members are, get them all to sign a resolution, and we're done, right? It's going to be as easy as that. This is just to give you some background information, right? So let's talk about the authority of the members to bind a closed corporation. Okay, so what do we do if I have a closed corporation? The closed corporation wants to dispose of a property. What I do, first of all, I'm going to look and see, do I have an association agreement? So an association agreement is an agreement that you can draw that more closely sets out the rights and obligations of the various members of that closed corporation. Most people simply don't have an association agreement because it's an extra expense, and people just generally don't go to the trouble of having one. So if there's no association agreement, well, then the conduct of those members is then regulated by the Act. So the member's authority to sell or to purchase immovable property is regulated by Section 46B of the Closed Corporations Act. And essentially what Section 46B says is that you need to have at least 75%, okay, of the members agreeing to sell or dispose of immovable property under the circumstances. Okay. So what you would have is you would have a closed corporation. Again, a closed corporation would call for would draw up a resolution. We'd call a special or general meeting. Everyone would arrive at the meeting. We would then have it. Well, we would want to have a quorum of 75% of the members being there. And of course, once the quorum is there, of that 75%, I need 75% to vote in favor of the resolution. Guys, I can also have what's called a round robin resolution. And the round robin resolution is what we do every day in these scenarios. We drop a resolution, the guys arrive, everybody signs the resolution, and that's then valid and binding on the parties. So again, guys, this is just a little bit of extra detail. I'm not expecting you guys to know this. What you do need to know is that you need to have the resolution, and all the members must sign it. So just for your interest, guys, what happens when the members disagree? All right. So in terms of the latest trends and the latest legislation, there's this move towards looking after minority interests. So let's say you got four members, or you got two members, one owns 75% and one owns 25%. So the 75% majority member, he wants to sell, and the 25% majority the 25% minority member doesn't want to sell. Well, the majority member can call a special general meeting, send out a notice. He is the quorum, so as long as he arrives, he's the quorum. And as long as he votes, well, then he's going to pass his resolution, and it becomes, well, tough luck for the minority shareholder. So what happens is there is a section 49 of the Act, whereby the minority member can now approach a court and complain to a court and say, hold on, this is not fair. You know, I'm not. This is not fair, because now because I'm the minority member, the majority member's got this blanket power to overrule me every single time, and I don't agree with it, and my rights are infringed, and the minority member can go to court and ask the court to overturn that decision. How often does it happen? Well, never in these residential type transactions. Why? Because it's so expensive to go to court. But if you are if you're in a company, or if you're in a closed corporation and there's a lot of money involved, and it's a bigger type closed corporation with additional interests, and you're the minority shareholder and you've been prejudiced, well, you may very well want to bring an application to court to enforce your rights. But again, guys, I'm not too worried about these details for you guys to note. Well, you guys must know company, closed corporation, trust. In the case of a trust, get your get your get your letters of authority, and get your trustees to sign the resolution. In the case of a company, get the resolution in front of you now. And of course, guys, I've got these resolutions as standard documents, which I can email to you. You can email it to your clients and they can fill it out. So this is your basic resolution of a company seller. Now I've got, for sellers and purchasers, companies, closed corporations, trusts, I've got them all. So if you need them, you email me and I'll send it to you. So resolution passed at a meeting of the directors and shareholders of X company, registration number, held at, on the, resolve that. Number one, the signatories here to agree to waive the minimum notice periods required for this meeting. That's one. Two, the prescribed notice with the prescribed information has been provided in terms section 115 and 164 of the Companies Act. Three, a quorum is established, okay? At least 25% of all voting rights present, okay? Remember, you have to have a quarter of all voting rights. Four, it is resolved that by at least 75% of the voting rights exercised, the company sells the following property, which property forms the whole or substantially the whole of the undertaking of the company, i.e., the property constitutes 50% or more of the company's asset value. And then what you do is you simply insert the details of the property, insert the full details. The purchase price shall be the sum of X. The sale is authorized in terms of section 112 of the Companies Act. And number 7, insert the name of the nominated director in his or her capacity as director. B, and is he authorized to sign any documents necessary to give effect to the triad and to sign the relevant documents which may be necessary for the registration or transfer of the property. So, guys, once you've got, once you've got this this resolution signed, now you have one person who you can deal with, that you can sign the sale agreement and can sign all my conveyancing documents. And 8, the following account is denominated for any refunds due to the company, and they have the bank details. Guys, I like to have the banking details now at this stage of the process. And the reason why I like the banking details there is because I have all the directors, all the shareholders signing this document and agreeing where's the money going to be paid. Sometimes we find we have one director and then he wants the money to put into his own personal account. And it makes us very uncomfortable because we don't know if that was expressly authorized by the company. And then what we do is we have the directors and the shareholders sign the agreement. So, of course, guys, arising from this, one of the questions is, well, who are the shareholders? And I'm sorry to tell you this, but in terms of FICA, you guys are obliged to find out who is the beneficial owner of this company. It's one of the FICA requirements. That's the bad news. The good news is that CIPC has issued a directive that within 3 months, everybody who owns a company, closed corporation, must file with CIPC a notice to say who are the shareholders of the company, who is the beneficial owner of the company. So if I have a company that's owned by a company that's owned by a company that's owned by a trust, well, I must give FICA for all those companies and the eventual trust and the eventual beneficiaries. So in other words, who is the warm body? This is something that's international jurisdictions have done for a long time. We are now playing catch up, and it's part of the government's efforts to become more FICA compliant, so we can move out the grey listing. So at some point in the near future, we'll be able to do a CIPC search, and it'll tell us who the shareholders are. For now, we must get our directors to get us a letter from the auditors to say who are the shareholders, so we can make sure that all the right shareholders are signing. Okay. The next slide is for a closed corporation. Guys, it follows pretty much exactly the same format, where it's resolved that the closed corporation sells the following property. There's a certain member of the closed corporation that's authorized to sign. I've got the bank details, and then you see at the bottom it says to be signed by every member as per the CIPC printout. If it comes to trusts, resolution passed with a meeting of the trustees of X held at on the resolve that the trust sells the following property for the sum of number 2, we insert the name of the trustees authorized in his capacity as trustee to sign all documents. Number 3, we got the banking account details, and then lastly is to be signed by all the members of all the trustees per the letters of authority. So this is a document. As soon as you list the property, you have this document, you give it to the trustees, and you ask them to sign it together with all their FICA information. And once you've done it, you've done it, and then you are then compliant. Okay, guys. So that's it. I just want to see if there's any questions. When do you get this signed? Yeah, as I'm saying, Jane, I assume that you're referring to the resolution. Certainly for a company and closed corporation, I mean, a company, a trust, please get it signed before your sale agreement. In the case of a closed corporation, we can sign after the fact. This is generally not a great idea. I would rather you get it signed prior to the date of sale. Also, for your purposes, we've come across examples where properties have been marketed, sale agreements signed, buyers have been found, buyers have got bonds, and now we do a CIPC search, and we say to the parties, okay, where's the 4th member? No, he doesn't want to sell. And then there's a dispute. Your transaction may not be able to go through because there's a dispute around the members, so it can become problematic. All right, guys, that's me. I don't know if there are any other questions. And I see there's Michelle's right on time.
Thank you, Marius. Much appreciated. And I look forward to seeing you later on this month.
Cool, guys. Yes. And thanks very much. Thanks for having me on your